always say that speaking after lunch is a bit of a bum deal at a conference because everybody's asleep, but having to speak after lunch and come after somebody like Johan Coetzee is very, very difficult indeed. I did psychology at university and I failed it hopelessly. But what he said resonated. Not only his remark about the edifice that is the body falling apart. I mean, with me, I really resonate with Prince Philip's remark that bits keep on falling off the ancient frame. But this notion of becoming so wrapped up in your career. I mean, this week I'm in South Africa. Last week I was in Paris. The week before that I was in Dubai. The week after next I go to France again. Then I go to Australia. Yeah, it's absolutely right. Meantime, my wife and the 3 kids are sitting at home. And I think we're all there. And what he said makes absolute sense. Dora and Theo just pointed out that the people who won the books were not gender representative. And it did strike me looking around the room that this is one of the few events that I've been to where it's advantageous to go to the ladies' loo, because the queues were shorter than they were at the men's. Anyway, the other bit of psychology that I do know is that you're supposed to get your message in really early as a speaker because people forget everything that you say after the first 30 seconds. So my message is this. RICS, South Africa, is busy building up a panel of built environment mediators to service the need that is being created by the Department of Justice's innovation in changing the civil court rules to place great emphasis on parties going to mediation early on, to the extent that if you fail unreasonably to do so, you're going to be lumbered with a costs order against you. That's the intention of the Department of Justice anyway. We have been training up built environment specialist mediators now for about 18 months in South Africa. We have a panel of about 50 people qualified. We are looking ultimately to have a panel of about 200. Members of the project management and construction management professions are ideal candidates for this. And I'm delighted to say that through Nomvula, we have developed excellent relationship with the SACPC H&SMP. That includes the health and safety people. So you heard it first from me, don't forget. Okay. But through Nomvula, we're delighted to say that RICS has developed a very, very good relationship with the Council, and we will be looking to work with the Council in building up this panel of specialist built environment mediators over the next couple of years. So I do hope you will become involved in that. So let me tell you a little bit about RICS, seeing that we've got it up on the screen. The Royal Institute of Chartered Surveyors is a strange old being. It's been around for about 150 years. It's been in South Africa for about 20 years. We're not a voluntary association. We're not a corporation. We are the strange object called a chartered institution, which means that we were created by Royal Charter initially under Victoria, and it's been confirmed by every monarch since. And our function in terms of the Charter is twofold. It's to protect the public, and we do that by 2 mechanisms. One is the regulation of our members internationally, and we are the biggest organization in the built environment internationally. We've got about 180,000 trainees, students, and members worldwide. If any of them steps out of line, regulation jumps on them pretty fast. And the other thing, of course, is to set international standards in many aspects of the built environment, from land surveying through to valuation, taking in project management, facilities management, construction management, construction, all the rest of the disciplines across the built environment. We have 28 professional groups whose function it is internationally to set that guidance and to set the standards. My job within RICS is that I'm in charge of our dispute resolution functions from New Zealand through to South America. We have, since certainly the late Victorian era, been involved in dispute resolution in the form of arbitration, then later adjudication, and that came into play in Britain, expert determination, expert evaluation, and over the last 30 years or so, of course, mediation, as that has become part of the legal framework around the world. I run DRS, Dispute Resolution Services, within RICS. We make about 3,500 appointments internationally per annum. making us the biggest appointing body in the world as far as dispute resolution is concerned. So that's what it is. I think I've talked about that slide now, so I can move on. There we go. This morning we heard all sorts of figures in the billions, and we heard a great deal of mega picture type information was thrown at you. I want to do the opposite. I want to take us right down and focus on something small enough that even I can understand it, and then we can build up from that to look at how dispute resolution works. So, I want to introduce you to the idea of the Eastern Cape. Have any of you heard of the Eastern Cape? Have any of you actually been to the Eastern Cape? God, for a bunch of Valis, it's pretty adventurous. I was born in the Eastern Cape. My family have been there since 1820, during which time we have raised cattle and married our cousins, which accounts for a great deal. My wife, who's from Buckinghamshire, still is surprised when we go to dinner in the Eastern Cape and I discover within 15 minutes that I'm related to everybody. But be that as it may. We've got a house in a little place called Kids Beach, and tomorrow evening I will be walking along that very beach. I don't know if any of you have ever heard of Kids, it's near East London. There's been a lot of development at Kids Beach recently, and I want to talk to you about Jacob and Thandi Jongilanga. I love that name, Jongilanga. Look at the sun. It's perfect for buying a house at the beach. Anyway, Jacob and Thandi. Jacob worked for, he was a project manager, and Thandi worked for SAC PCMP. And they've retired, and they have sunk their life savings into a townhouse, in a townhouse development, somewhere there in the Veld, just inland of Kids Beach. Our house is down on the lagoon, which is quite nice. Anyway, the story is that they bought this place on plan. So they had a long conversation with the developer's architect and the developer's consultant and the interior decorator and everybody else, and they decided how their townhouse was going to be built. And 6 months later, they've gone back, and things are not quite what they expected. Little things like the granite worktops in the kitchen are in fact chipboard. Because they want to retire there, they had asked for the staircase to be changed so that if they ever need a stair lift, they can put it in. The bathroom was a bit squashed, so they wanted that redone. None of that's been done. It's exactly as it is. They've discovered that the next development down towards the coast has got a 3-story house that's been built right in the middle of their view of the sea, so they can't see the sea anymore. The property's on a bit of a slope up there. And during the floods that they had earlier this year, one of the retaining walls washed away and most of the land has flowed down. And to make matters worse, it looks like the developer's going under. He's ducking and diving. They can't get hold of him. The person at the little development office is now a student on a vac job. The builder's left site, says that the developer hasn't paid him, so he's not going to do anything. And Jacob and Thandi don't know what to do. Now, as project and construction managers, you'll also see the whole raft of other disputes that will arise out of this situation. Disputes between the contractors, the subcontractors, between the contractor and the client, between the developer and the contractor, between all of these people. It's rife with disputes. And I think you'll agree with me that the scenario that I've mapped out, which I hasten to add is entirely fictitious and bears no relationship to any real or imagined development in Kids Beach before anybody sues me. Okay. I use it merely as an example. What do these poor people do? Well, there are different ways of resolving problems. So there's litigation, arbitration, mediation, expert determination, adjudication, negotiation, conciliation. Wouldn't go to a dispute board. Stakeholder consultation, independent decision-making, ombudsman, early review. All of these things are ways of alternative dispute resolution, which stands for, which ADR, as lawyers say, alarming drop in revenue. So, you see, some of you are awake after lunch. That's really heartening. You can go to litigation. Love the judge. Trouble with litigation is that it's bloody expensive. I mean, Jacob and Thandi haven't really got the money to go to court. Who the hell do they sue in that mishmash of problems that are there? It's going to take forever. They're going to have every expert from here to the Limpopo is going to come and have to give evidence at this thing. By the time they eventually get a judgment, Some of the parties will have gone under and they won't be able to recover anything anyway. And they are going to go along to a court who is obliged to only consider the legal aspects of the case. There can be no commercial considerations taken into place. If somebody comes up with a deal, the judge can't look at it. I mean, you can't stand up in court and ask a judge to consider something that is not in the pleadings. He won't and cannot do so. So a court is restricted in that basis. They could go to arbitration, which is in essence private litigation. It costs just as much. In fact, often it costs more because barristers like me can stand up and talk forever at an arbitration, and the arbitrator doesn't generally tell them to shut up, whereas a judge who knows his business will say, "Thank you, Mr. Fletcher, I get the point. Would you like to move on?" It's expensive, it's complicated, it's usually run by lawyers, not necessarily specialists from the built environment, and again, it's restricted to purely legal issues. Adjudication is something that we use now in the UK a lot in construction circles. In essence, you call in an adjudicator, it's time limited, he has to give a decision within 28 days, and it's an interim decision. The whole object of the exercise is that it remains binding and can be executed on until such time as either the parties take the dispute either to court or to arbitration, at which point it can be overturned. 90% of the cases it binds them, because what the parties really want is a decision so they can move on. It's subject to its own problems. It's become too legalistic. Lawyers have got involved, and again you're seeing people waiting until final accounts and then taking a final account to adjudication rather than interim matters, which is what it was designed to do. So it's not entirely without problems. We appoint about 1,000 adjudicators a year internationally. Big in Australia, it's being introduced into New Zealand next year. The Canadians are looking at it yet, but South Africa hasn't got it. It's something that RICS is very keen to see established in South Africa, but I'd be lying to you if I said it wasn't without some of its own problems. Expert determination, again, would be ideal. You bring in an expert who is an expert in the area, and he would either give a binding decision or an advisory decision. It can be quicker. It is a service that RICS offers internationally. It is something that could be used, but again, not hugely here in South Africa as yet. And then, obviously, what I wanted to talk to you today about is mediation. Now, mediation has been done something of a disservice. When it first came across the pond from the States in the 1960s, tail end of the 60s, 70s, it was very involved in labour. It still is in this country very involved in labour dispute. It was involved in community dispute. It was involved in education mediation, family mediation, very much at the soft counselling end of legal disputes. In fact, I was over in Jamaica a couple of years ago and I was talking to their people about mediation. What's happened there is that they have introduced mandatory mediation into the high courts. And I was over working with the utility providers. So we have the electrical people, water people, they don't have gas, and telecommunications. And what you've got is you had a huge big telecom equivalent over there, which has been privatized and broken up. Now the new boys on the block, the mobile operators and the satellite operators have come in. There are endless disputes going on about termination rights, termination contracts, rights to satellite access, right to cable access, and so on. And they've introduced mandatory mediation. Now, they've had mediation in Jamaica for years. In Kingston shares with Johannesburg the title of murder capital of the world. And, but when you look at the figures, it's not that they're murdering tourists. It's people in the community murdering each other on a Friday and a Saturday night after having consumed large quantities of ganja and booze. It's a bit like being at Rhodes, where the motto used to be, why drink and drive when you can smoke and fly? Except that we didn't kill each other. Okay. And their mediation has been run by very well-meaning volunteers for a long time who are community-orientated people who give of their time and their effort to settle matters within the community. Lovely people, but they are now being asked to mediate disputes over termination rights to international communication links. And they ain't got a clue. Okay. And in fact, I was busy talking to the head of their mediation service, and I had their chief trainer who was sitting next to me, and I can't do a reggae accent. But in the middle of this conversation, he suddenly said, "You know what I do, man?" And I said, "No." He said, "I get them to write a poem." What? He said, yeah, they must write a poem, no more than 4 lines, about why they loved a mediation. And yeah, well, I can see why you chaps have a problem with getting these cases solved. You know. But anyway, what has happened in real life and the way mediation has developed internationally is that you now see a very hard-nosed, commercially realistic approach being taken by mediators at the hard end of the mediation spectrum. RICS only works at that end. We don't do personal injury cases, we don't do family cases, we don't do labor cases. We do hard-nosed commercial mediation cases where there are contractual disputes between parties, typified by the example that I gave you a little while ago. And the mediation is conducted by built environment specialists who bring with them 20 years plus, expertise and experience in their particular field. And the object of the exercise is that by the time the parties walk out of the mediation, or from the mediation, what they have is either a settlement agreement, or they have a bloody good idea of what would happen to them if they took the matter to court. And that in itself generally brings about a narrowing of the issues, which in itself saves time in court, generally paying for the cost of the mediation quite well. That is the model that RICS operates on. It is a robust, muscular, hard-nosed, commercially realistic approach to mediation. And that is what the people who are currently on our panel have been trained in. That is the service that we'll be offering in South Africa, and that is the service that I invite you, as members of the project management and construction management professions, to become involved in. Just to look at some of the mediation myths and almost myths that have followed. I mean, generally there was an idea that the public would choose between mediation and litigation. That hasn't happened. People don't phone up their local mediator. What they do is they go to see their attorney, and it is the attorneys, the legal advisors in big corporations. Sometimes in the construction world, it is the project managers or even the architects, but the professionals who send the clients on to mediation. So again, within the context of this audience, that is a function which falls naturally within your scope. The idea that anyone can become a mediator, again, absolutely true in theory. It's not what's happened in practice. If you look at the major mediation service providers around the world now, you will find that they have their mediators classified by specialism. So you've got mediators who do personal injury cases, family cases, intellectual property cases, IT cases. We have mediators who do built environment cases, and that's our specialism. Mediation is a nice, gentle process. Well, not the ones that I've been to, and certainly not the ones that I conduct. The way a mediator adds value, you have this thing which is called reactive devaluation in negotiation. It's a big, fancy psychological term. What it means is that parties reject something that comes from the other side simply because it comes from the other side. Because they say it, it must be bullshit. That's the basic underlying message. If you know your job as a mediator, you will force people to confront arguments and to confront realities that they might have refused to confront had it simply emanated from the other side in bilateral negotiation. That's what it's all about. That's what you train to do. You refrain by making the unacceptable acceptable. People come to you with a story, it's full of emotion, it's not particularly logical, it hasn't been prioritized, they haven't worked out which aspects they're prepared to negotiate away, which aspects are non-negotiable. It's your job as the mediator to help them go through that process, to turn what is unacceptable into something which is acceptable to the parties. You will read in the literature about mediation that it is a win-win type process. Generally, it ain't win-win at all. It's lose-lose. Because what the parties come out with at the end of the day is a settlement that they can live with through gritted teeth, because it's better than anything else. But if you think that they're going to come and hug you as a mediator, you're totally wrong. Think about your fee and be happy. And the other thing, of course, that you're involved in, and this is what we specialize in, is vigorous reality testing. You never tell them what to do, but by goodness, you make them face up to what would happen to them if they took it to court, what they're going to be cross-examined on, and what the weaknesses of their position are. And that is why we use built environment specialists, because they know. They can go in there and they can assist the parties to actually get a holistic view of what they're doing. Talked about the changes in the South African court rules. If any of you don't recognize it, have any of you been to Bloemfontein? Goodness me, more of you have been to the Eastern Cape than to Bloemfontein. That says something. Okay. That is what is now the Supreme Court of Appeals building in Bloemfontein, the old appellate division. I should know that. If the South African court rules change, as we expect them to, they have abandoned the idea, which has been prevalent for the last couple of years with the Law Commission, of making mediation mandatory. But what it is now, it will be modelled on the Wolf reforms of the UK civil laws, which says that if you fail unreasonably to go to mediation, you can expect a cost penalty when you go to court. So there will be a huge amount of pressure brought to bear on parties to mediate. And in the built environment, I think it is particularly apt that it's a mechanism that people should use. So to sum up, what RICS offers, and it sounds like an American byline, but it's true nonetheless, we offer expert dispute resolution in the built environment by built environment experts. And I invite you to join us. If you've got any queries, please either contact me, J. Fletcher at RICS.org, or Alexandra de Beer, who's our representative in Cape Town, a de Beer at RICS.org. Ladies and gentlemen, thank you.